Good evening once again. The next part of our report will talk about rights implications of the lessor and the lessee. What are the obligations of the lessor? Article 1654 of the Civil Code provides for the obligation of the lessor. First, the lessor is obliged to deliver the thing which is the object of the contract. The object must be in the condition fit for the use intended. Second, the lessor is obliged to make necessary repairs in order to keep the thing suitable for the use to which it has been devoted, unless there is stipulation to the contrary. Third, the lessor is obliged to maintain the lessee in the peaceful and adequate enjoyment of the lease, for the entire duration of the contract. This obligation of the lessor seeks to protect the lessee, not only from the acts of third persons but also from the acts of the lessor. In addition to those provided in Article 1654, the lessor is obliged not to alter the form of the thing leased. Lastly, the lessor has the obligation to protect the lessee covers acts of third persons and of the lessor. Following are the rules on alteration of the form of the lease. Article 1661 states that the lessor can alter the lease, provided there is no impairment of the use to which the thing is devoted under the terms of the lease. To constitute alteration, the modification must be in such a manner that it would destroy the substance of the thing leased, unserviceable for the use intended. Moreover, the lessee can alter, as long as the value of the property is not substantially impaired. How about when the lease contract contains right of first refusal? The rule is that the lessor is under a legal duty to the lessee, not to sell to anybody at any price, until after he has made an offer to sell to the latter at a certain price, and the lessee has failed to accept it. The sale in violation of such right is nevertheless valid. However, it may be rescinded or may be the subject of an action for specific performance. Rules in case of useful improvements and ornamental expenses. So what are the rights of the lessee in case of useful improvements? First, the lessee has the right to remove the improvements, should the lessor refuse to reimburse, although the principal may suffer damage. Second, the lessee has the right to be reimbursed by 1/2 of the value of said improvements, at the time of termination of the lease, should the lessor choose to appropriate it. The lessor is to pay only 1/2 of the value of the improvements at the time the lease terminates, because the lessee has enjoyed the same. On the other hand, the lessor will enjoy them indefinitely thereafter. To be entitled to either of the two remedies in the preceding slide, the following must concur. 1. The lessee must be considered a builder in good faith. Improvements can be considered made in good faith if they are not in violation of the lease contract. 2. Improvements must be suitable to the use for which the lease is intended, and 3. The form and substance of the property should not be altered. How about an ornamental expenses? What right does the lessee have? The lessee has no right of reimbursement, but he may remove the improvements, provided that no damage is caused to the principal thing, and that the lessor does not choose to retain them by paying their value at the time of the lease. Now, we go on the rules in case of urgent repairs. The Civil Code provides that the lessor has the obligation to make necessary repairs, and that the lessee is obliged to notify the lessor of the urgency of the repair. The Civil Code further provides that the lessee is obliged to tolerate the work, although it may be very annoying to him, and although during the same time he may be deprived of the part of the premises, if repairs last for less than 40 days. Who has the burden of proof? It is the lessor who has the burden to prove the urgency of the repair. What is the right of the lessee if the repair lasted for more than 40 days? The lessee can ask for reduction of the rent, in proportion to the time, including the first 40 days, and the part of the property of which he is deprived. However, if the repair lasted for less than 40 days, the lessee cannot ask for reduction of the price, in the absence of the provision in the contract giving him such right or for rescission. It must be noted that in either case, rescission may be availed of, if the main purpose of the lease is to provide a dwelling place for the lessee, and the property becomes uninhabitable. If the repairs however are not urgent, the lessor is liable for any damages suffered by the lessee. What are the remedies if the lessor fails to make urgent repairs? The lessee has the following alternative remedies. First, he may order repairs at the lessor's cost, to avoid imminent danger. Second, he may ask for indemnification for damages. Third, he may suspend the payment of the rent, or lastly, He may ask for rescission, in case of substantial damage to him. In the case of Brandzone vs. Subai, it was held that if the lessor refuses to make urgent repairs despite notice, the remedy of the lessee is to make urgent repairs themselves and to charge the cost of the lessor, and not to suspend payment of rentals. So let's proceed to the obligation of the lessee. Article 1657 of the Civil Code enumerates the obligations of the lessee. First, the lessee is obliged to pay the price of the lease according to the terms stipulated. Note that only the lessor has the right to fix the rents. The lessor has the right to increase the rent in case of renewal. The lessee has the option to accept the new rate or vacate the premises, otherwise, he will be considered a possessor in bad faith of the property. Second, lessee is obliged to use the thing leased as a diligent father of a family would, devoting it to the use stipulated, and in the absence thereof, to that inferred from the nature of the thing leased according to the custom of the place. The lessee shall then be held liable for any deterioration caused by members of his household, guests and visitors. Third, to pay expenses for the deed of lease. However, this may be assumed by the lessor if agreed upon by the parties. In addition to those provided in Article 1657, the lessee is obliged to make urgent repairs even if annoying to him, unless the becomes uninhabitable. He is also obliged to notify the lessor of usurpation or untoward acts, which any third person may have committed, or may be openly preparing to carry out upon the leased thing. It is necessary to notify the lessor, so that the latter may bring proper action against the usurper. Further, it is unjust to compel the lessor to stand idly and trust the defense of his property to a mere lessee. The lessor is likewise obliged to notify the lessor of the need for repairs in the thing leased. However, notification is not essential if the lessor actually knows the need for the repairs. It should be noted that if the lessee failed to notify the lessor, he would be liable for damages, which the lessor would suffer, and which could have been avoided by the lessee's diligence. Lastly, the lessee has the obligation to return the property leased upon termination of the lease, in the same condition as he received it, save what has been lost or impaired by a. lapse of time, b. ordinary wear and tear, or c. inevitable cause or fortuitous event. That's all for the obligations of the lessor and the lessee. Thank you for listening.